Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group. We are excited to be back today with attorney Jennifer Coulter, and she is going to be talking to us today about advanced issues in special needs trust planning for disabled adult children on RSDI and disabled adult child benefits and Medicaid. So we're going to be taking a deep dive into those things today. I always go over a few housekeeping items before we get started. We're doing things a little bit differently today, so if you've attended in the past, we're going to change it up a little bit. First of all, I like everybody to know that we are in webinar mode today, which means that we can't see you or hear you, but we know you're there and we are glad that you have joined us today. We do invite you to put your questions in the chat box. If you have emailed questions in ahead of time, have already sent questions in for today's webinar, we do have those and we're going to be addressing those questions during our time together. So I'm going to share a little bit more about Consolidated Planning Group for anybody that is attending for the first time. Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is nuanced in planning for special needs, but we don't do what Jennifer does. Jennifer, I always kind of liken and try to confirm what we do versus what an attorney does. They're going to create the legal documents. They're going to answer those legal questions and take you through those documents. They're the paper, and the legal documents are super important. We're going to be talking about those today, but we're the money. How much money do I need to fund a special needs trust? How and when should I apply for public benefits? How do I make sure I have money in the right buckets? Those are some of the things that we help families with. We put protection plans in place, lifetime care plans. We do a lot of transition planning. We help set up ABLE accounts, and we do a lot of advocacy by way of our webinars and planning for special needs. I myself am a parent to multiple adult kids with disabilities. And what I would say is I eat, sleep, and breathe this. This is what I do, and what I would say is it's hard. And I know this stuff. I know it backwards and forwards, and I would say that the journey is hard. It's always wondering, what do I need to do or not do? Crossing the T's, dotting the I's, having money in the right buckets, and knowing some of the different benefit programs that are available to you that are not always apparent and not always talked about or even told. I mean, I can't tell you the times, Jennifer, that I come across a family where they have a disabled adult child and mom or dad are drawing Social Security and nobody ever told them about childhood disability benefits under a parent's
Mhm.
record. So these are real things. And so it's always our recommendation here at CPG that when it comes to planning for your loved one with a disability, your situation is specialized. We do highly recommend that you work with a specialist, whether you work with us or you work with Jennifer, or you work with somebody else. We do hope that you will choose a professional that is specifically nuanced and well-versed in special needs, because all attorneys and financial advisors are not created equally when it comes to this space and this practice of law and financial services. So choose wisely on that. So one of the things that I wanted to say today that we're doing differently, our presenter today, Jennifer, is legally blind. And so we're going to be a lot more conversational today than slide driven. Everybody that has registered for today's webinar is going to get a copy of the slides and a link to the recording. But today, for presentation purposes, we're going to be a lot more conversational than we typically do. So I just wanted to give everybody a heads up on that. So Jennifer, welcome. Welcome back. Thanks for being here with us. Tell us a little bit about your firm and a little bit about your journey, and then we'll get started and dive right into the content today.
Sure. So I'm Jennifer Coulter. I am a partner at Townsend Allala, Coulter Kludt. We are an elder law firm out of El Paso, although we serve all over Texas, and we practice in New Mexico as well. Elder law firms in general are going to do estate planning, special needs trust planning, Medicaid benefit applications, and probates and guardianships in most cases. There are excellent elder law attorneys all over the state of Texas. If you are looking for someone in your area, one of the best resources you've got is the National Academy of Elder Law Attorneys, NALA. They have a list of all of their NALA attorneys all over the state, well, all over the country. And you can always use their website, nala.org, to find a lawyer near you and find somebody that you're going to be comfortable with. Getting the lawyer in place is one of the steps that you're going to need if you're looking at special needs trusts, if you're looking at guardianships or things like supportive decision-making agreements. But I think you're also going to want somebody like Consolidated Planning Group, because this is not a solo venture. This is very much a team effort, and having the right team in place is really important. When Allison says she doesn't do what I don't do what she does either. So we like to work with your whole team to make sure that you've got everything that you need. We're going to talk a little bit today about special needs trusts and how to use them with your disabled adult children. I hate that terminology. It is just not very person first, is it? Social Security has renamed theirs as childhood disability benefits, which I like a lot better. Medicaid still calls theirs disabled adult child. And part of what we're going to be talking about is we're going to define a few terms, try to disentangle some things that can really trip people up on the special needs trust side, but also try to talk about some of those various programs, because which programs your people are receiving makes a huge difference in what the special needs trusts can do. So let's first start with a little terminology about special needs trusts. There are multiple kinds of special needs trusts out there. We tend to kind of casually refer to everything that might be in that realm as a special needs trust, but really understanding what kind of trust you have or what kind of trust you need can make a huge difference. For example, let's say you are looking at your situation and you have a child with a disability and you really want to make sure that after you're gone, they're taken care of. You want to get money to them into a trust that doesn't hurt them for benefits purposes. That is going to be what we call a third-party settled special needs trust. That is going to be a trust established by someone other than the person with disabilities, funded with funds belonging exclusively to a person other than the person with disabilities, and with a trustee who is someone other than a person with disabilities. That is pretty much the limit of it. No sole benefit requirements, and here's a really important thing, no Medicaid payback provision in it at all. If you're seeing a third-party settled special needs trust that has a Medicaid payback provision in it, you should be extremely concerned. I once had a nice young lady come to me. She was on the spectrum. She was very high functioning. She was sometimes able to work, but she had some difficulties staying employed. And she brought to me her father's will and said, "Can you review this and just see what it does?" And I looked at it, and it created a special needs trust with a Medicaid payback provision. A testamentary trust, one created in a will, is always going to be a third-party settled trust. And that is really important because that doesn't require a Medicaid payback provision. Fortunately, her dad was still alive, and we were able to talk to his lawyer and say, "Hey, I don't think you need this here." So we were able to work through that. But sometimes those things go in. So you really want to make sure you know, where is this source of money coming from? Who is setting it up? And what provisions does it need to have? The reason that we're going to talk about Medicaid payback provisions is the second kind of special needs trust. Most people think of this kind of special needs trust when we talk about it. This is the self-settled special needs trust. So a self-settled special needs trust is created by a statute at 42 USC section 1396 PD4A. You'll sometimes hear these called D4A trusts or first party trusts. These are trusts that are created by the person with a disability, their parent, grandparent, guardian, or the court, they are funded with funds belonging to the person with disabilities. Where we see these a lot is people who receive inheritances through the rules of intestate succession. So they receive inheritances outright instead of into trust, or instead of through a will that we can reform. In Texas, we can come and probate your will. And if your will doesn't have a special needs trust in it, but you have a special needs trust beneficiary or a special needs beneficiary, we can come in and say to the court, hey, court, this person totally would have meant to do a third party settled special needs trust in their will if they'd known about it. Can you reform this will to make it seem as though it always had that trust in it? And the court can do that retroactively. They can change the terms of the will to include it. But that's not always the case. Sometimes people receive inheritances through things like beneficiary designations. I had a client who the mom had done a beautiful will with a beautiful special needs trust in it, but all of her assets passed by beneficiary designations to her kids, including the child who had disabilities, except a 1989 Toyota Camry. So the special needs trust would have been funded with 1/4 of a 1989 Toyota Camry, and like $150,000 went to the beneficiary outright.
So let's
So
talk about that for a second, Jennifer.
sure.
Because this is a common thing that we talk about regularly because there is some misconceptions out there that when I do my legal documents with an attorney and I have a will and a family trust and a special needs trust, that dictates exactly where the money's going. But what people don't understand is those beneficiary designations trump everything. So we're talking
Mm-hmm.
about your investment accounts, stocks, bonds, mutual funds, 401ks, 403bs, pensions, military pensions, all of those things. The beneficiary designation trumps that. And so people think they just forget that last step sometimes. So it's so critically
Absolutely.
important. And one of the things that you mentioned just a moment ago about a Medicaid payback and a third party special needs trust, we've definitely seen that many, many times. And what
Oh,
I would liken that to, this is why it's highly my suggestion, whether work with Jennifer, you work with us, whoever, work with a professional that knows what they're doing, because we've definitely seen this a lot. And this is when you're working with an attorney that dabbles in special needs or they've never done
mm-hmm.
special needs. They're not familiar with public benefits. They heard through the grapevine that special needs trusts have to have a Medicaid payback, but they forgot and or didn't know that it was only for the first party special needs trust. So this is why it's so critically important, and I'm glad that you are addressing
Mm-hmm.
it. And I just want to one more mention on the beneficiaries. If you're taking notes today, it's wise to make a note. Check my beneficiaries. Life gets busy and we do these things. We do it in passing. We're hurrying it up and we're trying to fill out our HR forms for benefits at open enrollment or whatever. Sometimes you don't even have beneficiary designations on there. So it is easy and cheap to change your beneficiaries. You can ask for the form. Now, if you don't have a special needs trust set up, clearly you're going to have to work with an attorney to get that third party special needs trust set up. But looking at your beneficiaries, who is your primary beneficiary? And if I die and my primary beneficiary is dead and gone, then who is my contingent beneficiaries? And
Mm-hmm.
quite honestly, what we see very common, Jennifer, is that people will name their spouse if they're married, the
Uh-huh.
100% beneficiary. And if I die and my spouse is dead and gone, then I'll just divide it equally amongst my children, my heirs,
Mm-hmm.
right? And that's where we get messed up on that. So I think I just want to mention that. So check everything, not just your current employer and benefits through your current employer. I'm talking about outside life insurance that you've got with an outside company. I'm talking about old pension plans. And one thing specific that I want to note is that the National Defense Act of 2015 changed the law, the Howard P. Buck McKeon National Defense Act, to where a military pension could be directed to a first party special needs trust. So if you're on here and that's you, you should know about that, because I would say that it is widely not known in the military community that that change occurred.
It was such an important change. Um,
Huge.
there are a lot of things that can be directed to a self-settled special needs trust. If you're getting child support for your adult disabled child, and Texas does allow child support to be ongoing past 18 or past high school graduation, if the child has disabilities, you can continue getting child support on an ongoing basis. But we want to direct that child support to a self-settled special needs trust a lot of the times to make sure it's not counting as income to the person with disabilities for Medicaid purposes. So those are good reasons to create self-settled special needs trusts. Oh, one more thing I want to say about the beneficiary designations. Two more things. We call that accidental estate planning, because
Yes.
people
The
think they've
oops
got their
trust.
estate planning. Yeah, people think they've got their estate planning done, but then they don't follow up and change the beneficiary designations. One of the things that we like to put in our statutory durable powers of attorney, which each and every one of you should have, naming someone to handle your finances in the event that you're not able to do it yourself, in the special powers section. In the basics section, there's a power that says trust, estate, and beneficiary transactions. And that sounds like it will cover your estate, trust, and beneficiary transactions. But it really doesn't cover what we want it to cover on those transactions. So in your special powers, you may want to consider giving the agent the authority to change beneficiary designations if it's necessary, to name to change the name of an outright beneficiary to a trust, a special needs trust for the benefit of that beneficiary. Because sometimes we will come back when the parents are themselves incapacitated and needing benefits and look at the bank accounts and look at the IRAs and go, wait, we have a child with a disability and you've named them outright. And so that can be something that your agent can do, but only if given the express authority to do it. So,
Well, can we talk just a second? Because I know you touched on this a little bit, and there is a lot of confusion. You eat, sleep, and breathe this all day, every day on the first party and the third party special needs trust. So, in summary, the third party special needs trust is the way that we leave money for the benefit of said individual with a disability that will preserve their eligibility for state and federally funded programs such as SSI, such as Medicaid, etc., Medicaid waivers, things like that. That's the third party special needs trust. And then you talked about the first party special needs trust that has the Medicaid payback on that. And you talked about child support being redirected to a first party special needs trust. And I have to say, that is a big thing that is often overlooked, because it really
mhm,
didn't matter prior to the kid turning age 18, because it was
mhm.
based off of the parents' income and assets. They weren't getting SSI, maybe they weren't getting Medicaid. And then all of a sudden, it does matter, and we need to have that child support redirected to a first party special needs trust. So a first party special needs trust is good for child support, and then it won't count against them for SSI and Medicaid purposes. If it's the person's own money, the individual with the disability, it's their own money. They've earned it. Maybe there was a lawsuit or a settlement or something like that, or maybe somebody accidentally left them money, and it had to go to a first party special needs trust for that reason. But is there any other thoughts on the first party special needs trust? Because not everybody needs a first party special needs trust, but
No.
having, especially for the child support, I want you to talk about how you can't just open a first party special needs trust and have the child support redirected, that there needs to be a court order. It's not something like you
Mhm.
just go open a bank account at Chase, a first party special needs trust account, and redirect it. It doesn't really work like that. Can you talk a little bit more about that?
Absolutely. So we are talking now about self-settled special needs trusts, which are also first-party settled special needs trusts, or D4A trusts. We call them, you'll hear them called any of those kinds of things. These self-settled special needs trusts, they can't just be opened, as Allison says. They must meet a bunch of requirements first, and then I'm sorry, I was listening to what was coming in on the chat. We will come back to that question though. So for a self-settled special needs trust, it must be established by the person with a disability if they have a physical disability only and have the capacity, or by a parent, guardian, grandparent, or the court. If you're going through the court, you're going to end up with something called a 1301 trust or a 142 trust, depending on the court you're going through. If you're going through the guardianship courts, you have to end up with a 1301 trust. But that 1301 trust needs to be set up just like a regular self-settled special needs trust. It's just that we've got the court setting it up. So it must be established by one of those people. It must be established and funded before the person turns 65. That is not the same thing as a third-party trust. A third-party trust can be funded and established no matter the age of the person. But a self-settled special needs trust has to be funded and established before the person turns age 65. It must be for the sole benefit of the person with the disabilities. Now, the SSA in the past, they have been really huge jerks about that. There's probably a nicer way to say that, but they've been really huge jerks about it. It was very much like, oh, you're buying a couch. How many butts are sitting on that couch? More than just yours. That's not for your sole benefit. They're not doing that kind of thing anymore, but they are still really invested in making sure it is for the sole benefit of the person. It must have a Medicaid payback provision, not just if the person passes away, but if there's an early termination clause. So if the trust has any ability to terminate prior to the person's passing, the state must get paid prior to the person receiving it. So for, say, a 1301 trust, one we establish through the guardianship courts, the code that allows us to do that, Chapter 1301 of the Texas Estates Code, says it must terminate early if the person is no longer incapacitated. But what that means is if the person is no longer incapacitated and the trust must terminate, then the state has to get paid back, even though the person with disabilities is still living and could use those funds. It must terminate. You have to get that trust established first. Then you get a court order from the family court saying that the child support must be paid to that trust, not to the person with the disabilities. That has been a change in Texas law, since I've been doing this. We didn't used to have the ability to do it under Texas law. We were kind of sliding it in without authority, and advocating at the same time for a change in the rules, which we got. So now the family courts are really able to do that, but it's still not hugely common. And so a lot of times we get that child support and we're like, yay, we helped this kid. Except we may have helped them by disqualifying them from benefits that are worth a lot more to them than the child support they're getting. So that's a really important use of them. Some other retirement programs, other than the military pensions, which was a huge and important change, are also willing to designate them. So TRS has been reasonably willing to do it.
So when we're talking about that, to elaborate further, we were talking about specialists and working with a specialist. We likewise recommend that if you're working with a family law attorney because you are going through a divorce, there are family law attorneys that are nuanced in special needs concerns, and we do suggest consulting that. We have entire webinars on people with disabilities and kind of the divorce process and that kind of thing. But when you're talking about getting this child support redirected to a first party special needs trust, essentially they need two attorneys, the family law attorney that gets the court order to direct it to the first party special needs trust, and the estate planning attorney such as yourself that's creating that first party special needs trust. And I just like people to know that from a financial perspective, because they could be having legal fees for two. So we have a couple of
Yes.
questions.
Sure.
Could you elaborate on inheriting a car, which is not in the family living trust with a testamentary third party special needs trust. How would you put the car into that type of trust?
I'm sorry. Ask me the last part of the
So
question again.
basically, they're saying that they have a testamentary special needs trust, and how can they leave the car to the trust, to the third party special needs trust, is basically what they're asking.
So, if most vehicles in Texas are going to pass through your probate estate. There is a way to pass them outside of the probate estate. There's a couple of ways. You can put them into a trust, or you can do what's called a VTR, that's Victor Tango Romeo dash 121, designation of a beneficiary for a motor vehicle, and you can designate the trust as the beneficiary of the motor vehicle. If it's just the car and it's not a bunch of other assets, I'm going to tell you a special needs trust may be overkill for just a car, depending on the value of the car. One vehicle is going to be exempt for Medicaid purposes
And
um,
SSI.
and SSI purposes of any value. There are some programs like SNAP and TANF that have a limit on the value of the vehicle, and that can be important if you're trying to preserve those benefits. But for just a car, I will usually say you don't necessarily need it in the trust if it's just going to be the car, because it can cost quite a bit of money to get the trust set up. Uh, and then if you're only doing the car, you may not need it. But if you want to do it, you can do a testamentary trust in your will and just have the car not have a beneficiary designation on it. You can have a VTR-121 designating a standalone third party trust. That's one that's not created in your will. Or you can just put it into a trust right now.
Okay, thank you for answering that. We have a few more, and I'm going to run through and then we
Sure.
can continue on. Let's assume a parent needs long-term care Medicaid for themselves at some point
Mm-hmm.
in the future. How can such parents protect their Roth IRA from being spent down by Medicaid so the parent's adult disabled child can inherit the Roth IRA via the special needs trust?
Medicaid in Texas currently, long-term care Medicaid in Texas currently permits an annuitized tax sheltered annuity. So an annuity that is funded from your Roth to be protected against countability. Roths, of course, have no required minimum distributions, so you can protect it in that way by annuitizing it and having the special needs trust for the benefit of your child be designated as the beneficiary of that. This is something that Texas refers to as a retirement related or employment related annuity. Don't ask a financial planner for that because, as far as I can tell, Texas Medicaid made up those terms. What you're looking for is a tax sheltered annuity.
And then one thing that I want to mention on those tax sheltered annuities that you're speaking of, the Medicaid qualified annuities, um, not all states allow that.
Mm-mm.
There are a lot of states that don't, and so because we have people listening in from other states, that might not be an option for you if you are outside of Texas. So I just wanted to mention that. How
If you are outside of Texas, then, and your state does not permit that, one of the things that you can do is you will lose some of the tax advantages of the Roth. You can take distributions from it. Those distributions will be tax-free to you, and put the money from the Roth and any other assets, excess assets that you have, into what's called a sole benefit trust for the benefit of your disabled child. It does not create a transfer penalty for the parent, and it does not count against the child. This is kind of a hybrid special needs trust. It's being used to obtain Medicaid benefits for the parent while protecting Medicaid benefits for the child. The sole benefit trust rules and sole benefit trusts, I know I just said self-settled special needs trust must be for the sole benefit, but that's not a sole benefit trust. A sole benefit trust is going to be more like a third party trust. It's created by the person applying for Medicaid to put their excess assets into, it must be for the sole benefit, though, of the beneficiary that they're putting it in for. That person can be their child of any age or any person with a disability who's under 65. So maybe they've got a grandbaby who's disabled. As long as the grandkid is under 65, they can use it. Various states treat those differently because the federal rules don't say what all sole benefit means. Texas and New Mexico both say sole benefit means it must have at least actuarially sound distributions from it. So it must say the person has 32 years to live. In year one, the trust must distribute at least 1/32 of the trust. In year two, it must distribute 1/31, and so on. One of the things that people often look at is we've got an excess property where a parent has purchased a property that the adult child was living in. We can put that trust into it, and some states at least, will treat the free rent as actuarially sound distributions.
Thank you for that. And just another thing that I want to mention, and probably everybody gathered that, but just in case, because some families have more than one loved one with a disability, and they want to know, can I have one trust for all my disabled kids? And because it's for the sole benefit, the answer is you need separate trust, basically. When
For that kind of trust,
for a
yes. For
special
self-settled
for
special needs trusts, for sole benefit trusts, absolutely. For a third-party settled trust, you can have multiple benefits. You can have multiple beneficiaries of a third-party settled special needs trust, and you can tell your trustee, I want this money allocated equally between all three of my children with disabilities, or I want it allocated based on who needs it and have it allocated unequally, which is one of the things that a lot of parents have difficulties with when I tell them a sole benefit trust, we're going to have to do multiple separate sole benefit trusts because they don't know what the different kids are going to need going forward, and they want to have more flexibility than that.
so we have a few more questions that I would like to
Sure.
go through. So one person says, how specific does the name of the special needs trust need to be on the beneficiary designations? Include the date? What if it's updated?
The special needs trust, this is really going to depend on the financial institution, but generally speaking, I want to be as specific as possible. I want to make it the John Doe Special Needs Trust or the John Doe Medicaid Exception Trust, dated this date, trustee this person, um, because we don't want to have there be any errors. Trusts that get updated happen all the time. We still use the original date in naming conventions for it. But sometimes financial institutions are sufficiently fine with the Jane Doe Special Needs Trust, and they don't need the date.
Sometimes
Or,
they have a lack of characters in their
yes,
beneficiary designation and they can't fit it all in. And what my suggestion to you is, if that's the case, because it is the case with many financial institutions, that you ask for them to provide a letter confirming your beneficiary designations in full, the full written out name, and you keep that with your important documents. And that way it kind of lends itself to the where there won't be issues in the future.
for the financial institutions, one of the really important things you can do to make sure the funds are going to the correct trust. So you may have a third party trust and you may have a self-settled trust, and you may want funds to go to the third party trust, not the self-settled trust, or you may need them to go to the self-settled trust. Each trust should have a taxpayer identification number, and you should give them also the taxpayer identification number for that trust to help keep it straight.
I just want to mention on that, some law firms will get that tax ID for you when they're setting up your documents. Some don't, and you will need it to do it on your own. But I just want to give you a consumer plug here that when you go to apply for a tax ID, there are all kinds of scammy websites on the internet that are trying to sell you this and charge you $100 or 150 or 200. You need to go on the IRS website and request the tax ID. It is free. It is completely free. There's no charge. You can only request one tax ID, like for a special needs trust per day. So if you're getting one for the first party and for the third party, you might have to do it over 2 days. But there is no cost associated with this. So beware if you're running into something that, and the scary thing is these sites, they look really legit, but they are not.
Hmm.
So I just want you to know that. Okay, so we've got another question. You're answering such great questions here.
They have such great questions to
I
ask.
know, I love them. Okay, my
Hmm.
child has severe IDD, ASD, has class Medicaid, and is a disabled adult child, has a first party special needs trust the child support goes to, and an ABLE. I need a car for her care to take her to programs and appointments. Is it better for the first party special needs trust to buy or lease the car, or for the ABLE to buy it in her name? If it is in her name, do I need a guardian of the estate? She has none now. How does insurance work for this car since she will never drive?
Okay, that is a lot of questions. Let me make sure I'm running through them as best I can. And if I miss something on it, Allison, I hope you'll pop back in
Sure.
and make sure. So the issue with funding it from the ABLE account is the maximum you can put in an ABLE account in a single year is tied to the gift tax exclusion amount. The gift tax exclusion amount is something that, except for ABLE accounts, doesn't really matter to most of us because it's related to estate taxes, and the estate tax exemption is 14 million, just under $14 million per person. So most of us aren't going to worry about it. We worry about it the because the ABLE account uh, can only be funded up to the gift tax exclusion amount in a single year. This year, that's $19,000. I don't know if you guys have bought cars recently, but it's hard to buy a car on $19,000. And we generally are going to have other uses for that ABLE account money. We're going to talk some about that later. But having the self-settled special needs trust buy it is fine. Having the self-settled special needs trust buy it and distribute it out is also fine so that the person can own it. If the person is not going to drive it, though, it may be fine to leave it in the self-settled special needs trust so that the trustee hits fewer problems with the insurance of it. But it is possible for a non-driver to be the owner of a vehicle and have a driver insured. When I first went blind, I had when I went blind, I had just bought a car the previous month. It was super awkward, except I got to use the disability insurance to pay $0 for it. Yay! Small benefits, right? Um, so I couldn't drive it, obviously. My now husband was then my boyfriend, and he drove it. It took us a little bit of time to find an insurance company that would insure it, but looking around, you can generally find someone that will. Having it in the name of the trust, though, if you are the trustee of the trust, well, that's pretty easy to get you to be the insured driver, right? It's, your name, trustee. That's pretty clear to the insurance companies. The only issue with the special needs trust holding it is Medicaid payback provision at the end. So if that's a car you're using as your primary vehicle because you are primarily getting around with the kid, if they pass away before you, that vehicle is potentially recoverable by the state. So that can be a
Which
real
would be
issue.
also true for the ABLE account in this particular
Yes.
question. In the state of Texas, there is a Medicaid payback
Well,
on the ABLE accounts.
mhm. But the ABLE account wouldn't hold the vehicle.
Correct. It couldn't
You'd
be
use the
titled to
ABLE
an ABLE
account.
account.
Yeah. You'd use the ABLE account money to buy it, but you could use the self-settled special needs trust to buy it and then distribute it outright. Now, whether or not you'd need a guardianship for that is going to depend on the capacity of the person uh, in general. If they require a guardianship because they lack the capacity to handle their own assets, then yes, you may have to get a guardianship in place, in which case it may just make more sense to keep it in the special needs trust. I do want to real quick run you guys through some updates we've received from TMHP on payment from the self-settled special needs trust once the payback provision kicks in. Leslie Pickle is the TMHP person we reach out to for this. She came to the Special Needs Trust conference that those of us who do this attend every February. And she told us, and then I have put this into practice on several occasions, that number one, she can't find anything in the rules that permits Texas to recover real property, and they aren't going to force a trustee to sell a home in the trust. So one of the problems has been things like, I had a client who was taking care of her disabled child for years. She had dropped out of the workforce to be able to provide for the 24/7 care of her child. And the trust, the self-settled special needs trust, funded with the settlements from the personal injury suit, bought the house, owned the house, bought the car, owned the car. They weren't paying her for her caregiving. She had really nothing. And then her son passed away. And the trustee said, well, we're going to have to sell the house and the car and give everything to the state. The claim was for like $2.9 million. And I reached out to Leslie Pickle and said, hey, here's the situation. You're going to make this mom homeless and unable to do the job she has started to do since her child passed, which was like Ubering. And can you not do that? And she said, sure. And they settled that claim for $5,000. They are legitimately not recovering for houses. At the next year's conference, she told us, even though a special needs trust, a self-settled special needs trust payback provision must be for Social Security purposes for all benefits received, regardless of when they are received, they must be paid back. The state must be paid back for all Medicaid benefits received by the beneficiary. But Texas is telling us, and this is Texas specific, TMHP is telling us they are only recovering for the services received after the establishment of the self-settled special needs trust. Now that's the law for the ABLE account. It's not the law for the special self-settled special needs trust, but that's what they're doing. So getting somebody in there to work with TMHP when time for payback comes in can be really important. Y'all, I'm going to lean forward and see if I can make my phone that I am doing this on stop reading the chat aloud, because it's a little hard for me to hear myself over it.
Okay.
One moment.
And so while she's doing that, there was a thing in the chat saying this is so confusing. How many different types of trust are there? There are many different types of trust, but a first party and a third party special needs trust. There are three places that will not count against for state and federally funded programs, and it's the ABLE account, which is not a trust. We have entire webinars on the ABLE account. It's under the tax code 529A for ABLE, Achieving a Better Life for an Individual with a Disability. Then we have the first party special needs trust, which is where child support goes. And if the person has their own money or they've been given money or they have a settlement in their name, that's the first party. And the third party special needs trust is how we leave money to a loved one with a disability that does not have a Medicaid payback. And one question I get all the time, Jennifer, is why do I need a special needs trust and an ABLE account? And
Well, that's my favorite question.
I love that question too. And I mean, one is that there is a limited amount of money, as Jennifer already mentioned, that, you know, $19,000, the gift tax exclusion into the ABLE account. You can put an additional $15,560 for 2025 into an ABLE account if the individual with the disability is working and they've earned up to that amount. So if they worked and they only earned 5,000, then you could put an additional 5,000. But we can't leave a beneficiary. You can't make an ABLE account a beneficiary, whereas you can a special needs trust. But the cool thing about the special needs trust is you can have an unlimited amount of money in the special needs trust. So they work beautifully together, and the ABLE account can pay for things that will not cause SSI, supplemental security income, which we're not taking a deep dive on that. We're really talking more about DAC today and more advanced issues. But if you pay for shelter out of a special needs trust, right, Jennifer, then that would
Hmm.
reduce SSI by 1/3, whereas the ABLE account will not. But we do have deep dives on SSI and Medicaid and ABLE accounts and all of these things. So I do want to invite you to check that out on the YouTube channel. But I just want to be clear that an ABLE account is not a special needs trust.
I have two other kinds of special needs trusts to add there. So we've got our third party settled special needs trust, we've got our self settled special needs trust, we've also got pooled trusts. These are also federal creation. These are going to be trusts that are run by charitable organizations that pool all of the funds for of all of their beneficiaries for the purposes of investment, but keep separate sub accounts for accounting purposes for determining how much each beneficiary has. Um, those kinds of pooled trusts can be either first party or third party. First parties are still going to have a payback provision, although their payback provision is different. Their payback provision can be not just to the state, it can also instead be that you can give it to the trust itself to help offset the expenses for others. So usually, most of my clients who do pooled trusts use the ARC of Texas. They are not the only pooled trust, but you do want to be careful. Just like in selecting a private trustee or a professional trustee for your self-settled special needs trust, you want to be really careful in selecting the pooled trust. There was recently a massive scandal in which an organization that most people thought we trusted had definitely been embezzling from their beneficiaries because most of them didn't have somebody looking at the bank statements every month. So we also have pooled trusts. And then we've also got those sole benefit trusts that serve that dual function of allowing the parent to become eligible for long-term care without triggering a transfer penalty that could disqualify them for as long as 5 years, while protecting the benefits for the child. It is confusing, um, and you will want to really know how these things work together. Yes, the ISM is in-kind support and maintenance, counts for SSI purposes, but there are some other Medicaid programs it counts for, as well as regular Medicaid and SSI. ISM does not count for long-term care services. So the person who said that their child is getting class benefits, that's a waiver program, and the waiver programs do not count in-kind support and maintenance as income to the person. But the Medicare savings programs that will do things like, so you've moved from, the child has moved from SSI and Medicaid to childhood disability benefits and Medicare because their parents are drawing Social Security or their parents have passed away and they are now getting this bump in their benefits. In that case, you may still want something like the Medicare savings programs, something like QMB or SLMB, depending on how much their monthly income is from their childhood disability benefits. I'm sorry, their CDB benefits. The reason for that is those Medicare savings programs can pay the Part B premiums for the Medicare. They can cover the copayments and deductibles that Medicare isn't covering. And those do count in kind support and maintenance. So using an ABLE account for paying for the shelter expenses can keep that from counting against the person for Medicare savings programs as well.
We have a couple of quick questions, and we'll just run through these in quick answers. We've got about 10 minutes left today.
Oh, goodness.
With the sole benefit trust, can there be a remainder beneficiary?
That's going to be state specific. Texas and New Mexico, yes, absolutely. Some states take the position that in order for it to be for the sole benefit, it must have a Medicaid payback provision in it. For those of you in Texas or New Mexico, though, and a number of other states that I don't practice in and therefore not have a whole listing of, yes, you can absolutely create a remainder beneficiary for that.
And so with the annuitized payments, would they start immediately, not after the death of the parent? And that sole
For
benefit
the,
trust?
I think that question is probably related to the idea of annuitizing the Roth.
Perhaps. Yes, this was a while
If
ago.
that question is related to annuitizing the Roth, because the Roths don't require RMDs, you can stretch that out. You don't have to start taking distributions from it immediately. You can take them later. We can take them when the kid receives it. You're going to want to look at the kind of annuity you're receiving, though, to make sure that you're getting one that can be deferred properly. Can I make
Sure.
one quick question about IRAs? Or
Yes.
one quick comment about IRAs. So Texas, if you are in Texas out there, is treating IRAs and payout, traditional IRAs, not Roths, IRAs and payout status. That means you've reached your required beginning date. This year, that's 73, and you're taking required minimum distributions as completely exempt. Um, they should be treating IRAs that are inherited that way as well. So far, we don't have any written policy on this. They announced it at a conference and told us written policy was coming. That was in 2016 or 2017, and no written policy has come. But they are definitely doing it for the plan participants IRA, for the surviving spouse if they roll over the IRA and are taking the required minimum distributions. They should be doing it for inherited IRAs, but I have not yet had the opportunity to try that one out.
Okay, one person says they have an ABLE with 75,000 in it, and what my recommendation there, if you ask our friend Google how much you can have in an ABLE, and it's way more. I think it's over $500,000 now. I don't even know what it is for 2025, but your number is less than $100,000 if you want to maintain eligibility for SSI. So that would be a savings to spend account. We would spend that down. I want you to talk briefly. I know we're running out of time. In some states, they do guardian of the person and guardian of the estate, but
Mm-hmm.
basically there is a threshold, and I don't remember, is that number 20,000? Is that what it's up to now? That if you're managing assets for an individual with a disability outside of a special needs trust and an ABLE account, if it's less than a certain number, they don't really need guardianship of the estate in Texas. It's different in different states. So talk to us about that.
I'm going to tell you, we don't do guardianships in our office, so I have not kept up with the changing in the numbers.
Okay.
But when I was doing guardianships, my court wanted at least, if they didn't actually want you to be appointed guardian of the estate, they at least wanted you to tell them about the ABLE account, regardless of how much was in it. And
Mhm.
just real quickly for y'all, $75,000 is a lot to have in an ABLE account. There's two ways to get there. One is those annual contributions, then the currently 19,000, and then the additional earned income you can put into it. But another way is rolling over a custodial account.
One person says, have you ever seen a survivor benefit? So, we're talking about this disabled adult child. And
Mm-hmm,
again, we have entire webinars on there. I would think that most of the people on here, they had kids that were getting SSI, and then you turned on your own
mm-hmm,
retirement benefits and then applied for childhood disability benefits, which were formerly called DAC for like 40 years, disabled
mm-hmm.
adult child. Have you seen survivor benefits exceed the income level for the Medicaid waiver benefits of the 2901, leading to the loss of the Medicaid waiver funds? And I want to say that I spitballed this with attorney Allison Packard and a number of different people, but basically, because the DAC benefits, basically, when they go to survivor benefits, it goes from 50% of the parent's full retirement age to 75%. But there are some provisions, we looked them up, I don't know the exact name of them, but there are some provisions under the law that if their increase from the DAC benefits to the survivor benefits throws them over, then basically it's exempt, and they're not going to, basically what people are asking is, when I die and their benefits increase, are they going to lose their Medicaid waiver that they've been waiting for 17 years?
Pickle provisions is what you're looking for there. It's called the Pickle program. So yes, it is possible for it to go over, and yes, it is possible for it to be exempt. The issue is if they're also receiving, say, another pension, say they're getting both your Social Security and a veteran's benefit, um, that can bump them over too. But for waiver programs and all the long-term care programs except community attendant services in Texas, you can fix an income problem. And in New Mexico, if we've got anybody out there from New Mexico, you can fix the income problem with a qualified income trust. It's called an income diversion trust in New Mexico. So even if you bump over with the additional sources, I've seen that happen. I had a client with both um, CDB and workman's comp from different parents passing away, and it bumped them over. We're able to use a qualified income trust. You'll hear that called a Miller's trust based on the Supreme Court case to fix that income problem for long-term care programs like waiver programs.
For sure. There continues to be confusion in the chat box of the first party and the third party special needs trust. But just to
Sure.
reiterate, and we do have entire webinars on first party and third party special needs trust. No, there is not a Medicaid payback. There should not be a Medicaid payback in a third party special needs trust. And one person says, I have this trust and I have a friend to oversee it, but I don't want my home to go to Medicaid if the child passes before me. And is that an
Oh,
issue in a third party special needs trust?
no, not in a third party settled special needs trust. And in Texas, at least, and at least right now, not in a self settled because they're not recovering the real property. But that can change because that is based on TMHP's kindness. And I try never to rely on the kindness of agencies when staff changes. So I'm hoping Leslie Pickle stays there for the next 100 years. Um, but no, definitely not in a third party trust. I'm also going to be talking to y'all on what, October 22nd about the Medicaid Estate Recovery Program, um, which is not the same thing as the recovery that you're going to get in a self settled special needs trust, but something that a lot of people are afraid of. They're afraid to buy a trust or buy the home in the self settled special needs trust and distribute it outright to the beneficiary because they don't want that home to be recovered by the state, even though there's a lot of ways to not have it recovered by the state.
But
Um,
again, this is why it's so critically important to work with a qualified attorney that knows these ins and outs, because your average attorney does not know these ins and outs. There's a reason that there's a special needs attorney planning conference every year because
mhm.
things change and people find loopholes, laws are updated and wording is clarified and things like that. We have like 3 minutes left. We had a couple of write-in questions that one of the ones
Mm-hmm.
talked about the tax status for special needs trust. And what I'd like to say is on our YouTube channel, we have done multiple webinars with CPAs that are specifically nuanced on the taxation of special needs trust. I myself don't do that, and neither does Jennifer, but I do encourage you to work with a CPA that's nuanced in that, and do check that out on our YouTube channel. If you would like a copy of those slides, you can email us and we will be happy to send that to you. How can I make a special needs trust pay for my son's living, like or rent, without losing disability benefits?
It's going to depend on the disability benefits that you're receiving. If it's SSI and regular Medicaid, you're going to want to use an ABLE account. The trust pays the ABLE account. The ABLE account, because it belongs to the person, it's their own resources paying for it. It causes no diminishment. But if the child is no longer receiving SSI and is instead receiving CDB, CDB does not count in kind support and maintenance. They don't care about the person's income for CDB, except to the extent that income may be earned, and earned income means you may not be disabled anymore if you earn
So
enough.
that answered one of the questions of can a special needs trust fund an ABLE account? And it can, but one question was, can an ABLE account make a contribution to the special needs trust? And so I know that the ABLE account has the Medicaid payback and the first party special needs trust has the Medicaid payback, but the third party doesn't. So what are your thoughts on that?
Absolutely not. Well, certainly not to a third party, because remember, the ABLE account is the money of the person with the disabilities. That's how the Social Security Administration treats it. That's how Health and Human Services treats it. That money belongs to the person with disabilities, and we can't put money that belongs to the person with disabilities in a third party trust. I don't think, though, that you could make a contribution to a self settled special needs trust either. Hmm. At least not without paying a tax on it. The provisions for what an ABLE account can pay for are really pretty broad because they let the Treasury or they let the IRS define it instead of Social Security, and the IRS has no idea what they're doing with people with disabilities, which is great for us, because they said that basically qualified disability expenses are expenses for housing, food, shelter, education, or anything else that would improve the quality of life of the person. So there's very little you can't pay for the person out of the ABLE account. I don't think you can put it into a self-settled special needs trust, but I don't have a definite provision of law that tells me that.
Okay. We are out of time for today. There are additional questions in the chat box that we weren't able to get to today,
Oh no.
but we can follow up on that. But there were two additional write-ins that I want to make sure that we do cover. So if you guys just want to hang on for another minute or two. One person says, what happens after age 18? I'm so scared. He's nonverbal with IDD, autism, and I've heard so many stories. And I would say, I think educating yourself and attending these webinars and learning a lot of things change when your child turns 18, and whether or not you should explore guardianship or alternatives to guardianship, knowing that if you applied for public benefits in the past for said individual and they were denied, that it will be based off of their income and assets once they turn 18. And so you probably need to revisit that. And there is a lot of help out there for you. And I would say that our series of webinars and our YouTube channel was really just born out of my own frustration of why is this so hard? Why is transitioning into adulthood so scary? And so we've partnered with people like Jennifer and done all kinds of webinars to empower you and give you the tools and resources that you need to be successful on your journey. So don't stress over it. There is some, things and some steps, but we can help you align those steps. So that's again where you want to work with a specialist. The last
Start planning for that before the person turns 18.
Yes, I agree with that wholeheartedly. The sooner and the earlier you get started planning, the better. But I also always want to encourage for anybody that's sitting here and you're saying, "Oh no, I'm a little bit late to the party." Okay, I always say it's not about looking back; it's about looking forward. And you're here today, and you're hearing it today that you need to get started. So don't beat yourself up about it. We can pick up where you left off and get you on track. It is easier for all of us, all the professionals that would be working with you, to get started earlier versus later, but it's not impossible. You haven't missed the boat. Even if your kid's 26 and you've never even applied for benefits before, you haven't missed the boat. And we can
Absolutely.
talk further about that. So don't feel discouraged. The last thing that I had, and I know that we sent an email asking for clarification of this question. When renewing Medicaid, how does long-term care affect it? And did you get any updates to that question?
I didn't before we started.
Okay.
I have a couple of things I think it could be. So there's a couple of options that it could be. I'm sorry if you're there and we didn't understand the question properly. It could be a question about if you have multiple types of benefits, because there are a lot of Medicaid programs out there. Texas alone has 109 programs we call Medicaid. If you're going to be renewing one kind of benefit, they're generally going to look at all of the benefits that you're receiving and renew them all simultaneously. But it may also be if you're renewing the Medicaid after you've gotten bumped off of things because you've transitioned from SSI to CDB and you've gotten that bump in income that puts you over the limit for regular Medicaid. If you're getting one of the waiver programs, you need to reapply immediately for that program to make sure that you don't get stuck back at the bottom of the lists.
And even
Uh,
if you're not getting a Medicaid waiver, so I just want people to know that whenever a child switches from SSI to childhood disability benefits under a parent's record, it's pretty normal and typical that you're going to get a letter in the mail from the Social
mhm,
Security Administration saying that Medicaid is ending, and the parents go into pure panic because the kid's getting an HCS waiver and they know they got to have Medicaid to have the waiver. The letter doesn't say, and oh, by the way, there's protections under the law that if the person was getting SSI and Medicaid first, that they're going to be able to keep Medicaid when they switch over to the CDB and the
mm-mm.
higher benefit. It doesn't say, oh, by the way, you need to submit a new H1200 Medicaid application for Texas and indicate. I suggest a cover letter. I suggest writing MEPD DAC Medicaid big on the top of the application so it gets routed
Mhm.
properly. And I suggest writing a quick cover letter just saying, my child was getting SSI and Medicaid and recently switched over to childhood disability benefits and as a result lost Medicaid. He or she is in the mandatory Medicaid group. Please reinstate Medicaid immediately. So
Absolutely.
it's a big deal, and thousands, hundreds of thousands of people have got this letter, and I can't tell you how many people, Jennifer, that we have run into that did nothing because they absolutely did not know because the letter didn't say that they needed to reapply, and then when they called the
It's not
trace.
even really clear on the government websites
Well,
either.
it's also not clear with Health and Human Services, and
Mm-mm.
that's why I think it's so important to write big MEPD, DAC Medicaid, so it will get routed to the right department. Because
Hmm.
if it doesn't get routed to the right department, what we've seen is that the Medicaid application is denied because the income is too high. So it's a slippery slope. It is frustrating. You're not crazy. It is tough, but like we said, there's a lot of help out there for you. We pride ourselves on not going over, and we failed miserably on that today. So sorry for that. And again, this has been recorded, so everybody's going to get a copy of today's recording, and they are going to get a link. A copy of the recording and a copy of today's slides. Even though we didn't have the slides up on the screen, we're going to send the slides with the details that Jennifer talked about today. Jennifer, it's certainly been a pleasure. We will look forward to
Thank
being
you.
back with you in October. And thanks, everybody. Thanks for your great questions today. And we'll look forward to connecting with everybody again soon. Bye now.
Thank y'all.